Hey, listen. Listen. Come here. Listen, we got new documents. There's more legal stuff to talk about. I know I'm excited too. Super excited. Hey, what's up, everybody? My name is One Peg. In this video, we're going to be talking about a new motion that has been requested from the court. In this battle between Nexon and Ironmace, Nexon is suing Ironmace by saying that Ironmace stole information, IP that Nexon owned, and basically created Dark and Darker as a stolen version of their Project P3. Now, we have a lot of videos that go back in time over all of this, dating back to the original article, the news article that got written a long while back, that I believe I was the first person to make a video about, but it doesn't really matter. Anyway, we have a new motion from the defense. It is a motion for relief from the initial disclosures deadline and for a protective order to stay the discovery pending a resolution of their motion to dismiss. Now, I know that sounds like a lot, but this is what it looks like. Now, to break this down, it's another motion for relief from initial disclosures deadlines. So the initial disclosure is like an outline. It's a plan of action that gets presented in a conference to the judge where all of the counselors, well, the main primary counselors, sit in a room at a table with the judge and talk about what they plan on doing, what they're going to produce, who they're going to talk to, meaning witnesses, what testimony they're going to get, what they're going to need in order to be able to get that done. It's all going to be in a bulleted outline form, how much things are going to cost, and most importantly, how much time they believe it's going to take. Now, that disclosure has a date set on the calendar already by the judge for some point by the end of this month. That they're hoping is not something that they're going to need to deal with, which is why they've put this in here. Secondarily, what they've also asked is a protective order to stay discovery. Now, once they have the initial disclosures done, then there's the discovery process. Basically, the disclosure is an outline to say this is what we're going to go and get. Discovery is actually going and getting it and going through the actual process of getting all of that information together. And that's the part that starts to get expensive. But all of this hinges on a pending motion to dismiss. Remember, they've already filed a motion for forum nonconvenience to say that basically Korea, where this court case is also ongoing in parallel with this one and is basically the same as this one, that's going on in Korea too. And they're trying to say that the Korean court case should just see its way through and they should dismiss this one because Korea would be the preferential forum. Now, of course, Nexon has disputed that and said that, well, the United States actually has a more robust, more stringent court system that would demand certain pieces of information be shared with the court and with each separate party, and Korea doesn't have those legal rules. So we don't know whether or not this is going to stay in the U.S. or whether or not it's going to be dismissed. If it gets dismissed, that's actually really good for Ironmace. That means that the DMCA claim no longer applies, at least not in the United States. It's possible that if it does get dismissed, the judge could even potentially end up putting something in with prejudice to say if Nexon tried to levy this suit again before seeing the Korean court through, they could end up having penalties levied upon them. I don't know if that's necessarily going to happen, as it doesn't seem like they're really all that overreaching, at least not in the documentation. But it is very, very possible and likely even that we could see this get dismissed. But here's the rub. We're actually going to see that today, because by the time most of you see this, it will be on the 14th. In fact, it's a little bit after midnight on the 14th right now, which means that today on the calendar in the Seattle court, there is actually a set up meeting time for all of the participants in this to get together and have an oral argument in front of the judge. So if that gets granted, awesome. If not, we'll have to see if this is something that they end up granting. But the reasons why are outlined in here, and we'll go over it super quick. The defendants request a stay of discovery pending resolution of the defendant's motion to dismiss on grounds of forum nonconvenience. Defendant's FNC motion raises only questions of law and, if granted, would dispose of this entire action in favor of the existing proceedings already underway in Korea. Now, as explained in the FNC motion, because this case solely involves activities in Korea by Korean nationals and nearly all relevant documents are in the Korean language, extensive and costly foreign language translations will be required in order to investigate and prepare fulsome initial disclosures and discovery responses. As such, good cause exists for the court to stay discovery and stay or vacate the initial disclosures deadline pending resolution of the FNC motion. In short, what they're trying to say is that Korea already has everything that they would need in order to be able to figure this whole thing out. Obviously, Nexon is going to argue, like they did in their challenge to the dismissal originally, that they don't really have everything. Now, again, my understanding is that it all comes down to source code. Ironmace has always said that they would share that source code with an independent third-party reviewer, and Nexon, as far as I am aware, has not agreed to that. Although Nexon, as much as they would love to say this, has spun it to say that Ironmace is actually refusing to give that information to the court, and really what they mean is to give it to Nexon so that Nexon could review it themselves. So take that with a grain of salt. Now, this lawsuit is brought by a Korean video game publisher, etc., etc., etc. The parties have already engaged in litigation over identical issues in Korea. All of the witnesses with knowledge of Nexon's allegations both work and reside in Korea. All of the relevant documents are in Korea and are almost exclusively written in Korean. Now, they go on to say that the reasons why, mainly the reason why here, aside from precedent saying that you can be granted a stay because the court has the authority to be able to do that if they want to, if they see that it's pertinent. The reason why they're doing this is basically around expense, because the Korean court is already doing what it's doing. In order for the United States courts to hear this, the defense attorney, for the very minimum, the defense attorneys, none of them speak Korean. In order for this to be heard in the United States, all of those Korean documents would have to be translated into English. And the estimation from the attorney's office is that would amount to several $100,000. As Nexon has already filed in its opposition to the defendant's FNC motion on July 10th, it concedes that no additional discovery is required for the resolution of the FNC motion. So the forum nonconvenience motion has all of the information that it needs from both sides to make a decision as to whether or not that motion should be granted. As detailed in defendant's FNC motion, all of the parties to this lawsuit, Nexon, Ironmace, Choi, and Park, are already litigating an identical dispute in the Korean court system. Accordingly, the location of all relevant witnesses and documents is already known. As set forth in the documents supporting the FNC motion, all relevant witnesses reside and work in Korea. So again, they're hammering home this idea of everyone is more or less in Korea. All of the information is already in Korea. And I would assume that all of the information that would have needed to be translated from English into Korean, if necessary, would have been translated or is in the process of being translated right now, as they already have, according to a news article that was written relatively recently, over 5,000 pages of documentation to pour over. And the court is currently in recess, but we should have an answer on whether or not there's going to be an injunction delivered by the end of this month. Again, regarding the finances, the burden on the defendants here is particularly substantial, where the discovery will be uniquely cumbersome and expensive. As set forth in defendant's FNC motion, given that the parties in the Korean proceedings have already produced thousands of pages of exhibits, the cost of translating all the documents in this case could easily exceed hundreds of thousands of dollars, if not much more. As none of the defendants' U.S. legal team speaks Korean, translation of documents would be necessary to prepare initial disclosures and any subsequent responses to requests for production, interrogatories, and requests for admissions. As all of the witnesses reside in Korea, costs associated with depositions and their translations would be substantial. I have to agree with this. If none of the attorneys, at minimum, if none of the attorneys in the United States for the defense speak Korean at all of that having to be translated at the expense of the defense, meaning Ironmace, would be a significant amount of money. It's obviously going to be way less expensive to litigate this in Korea. Now, there is the argument that Nexon has made where the Korean court system can't compel anyone to produce anything that they don't want to produce in pre-trial hearings. When it gets to the trial, I don't know how that works. But also, there is the question of timeline. See, in the U.S. court system, they have a delay to get people in for a trial if it gets that far of about a year. In the Korean court system, that delay can be up to 2 years. So I don't really know when we're going to end up seeing the light of day with this. But no matter what is going on, there's going to end up being a delay, and it's going to be, it seems, pretty substantial on the timeline. Quite honestly, looking at this back and forth, I think the judge could end up going either way. It really depends on what she thinks when she reviews this and listens to the oral arguments from either side. And not for nothing, I think it's really going to come down to the talent of the litigators in the room arguing their side and which one of them ends up just doing a better job. It's unfortunate that I happen to be on the East Coast, because if I had the budget, I'd be on a plane right now to Seattle just to sit in there, because I think it would be really, really awesome to check out. But at any rate, rest assured that I look forward to looking over the court's notes, checking out whatever the stenographer records, and seeing who did what and who said what and how well they did. In the meantime, though, if you wouldn't mind subbing the channel here, that would be pretty sweet. I'll make sure to get these documents up to Patreon for those of you that actually want to go to the Patreon and check them out. Otherwise, I'll see you guys live at twitch.tv/onepeg, probably around 7 to 8 a.m. Eastern Standard Time, I guess, this morning. Thanks so much, guys. We'll see you in the next one. Peace.